Good evening, everyone. You're very welcome to the fifth in this series of a collaboration of legal information webinars between the Ukraine-Ireland Legal Alliance and Irish Red Cross. Tonight, the topic is family and child law. We have three presenters from Mason Hayes Curran and Matheson firms, and also from the bar. We're going to start with our first speaker, first of our presenters. Our first presenter is from Mason Hayes Curran. And Shane, if you could turn on your video is there. Shane Reynolds from Mason Hayes Curran is going to start us off. And our session will start with three speakers, and then we'll go to the Q&A. So Shane, I'll hand over to you now.
Thank you very much, Rosemary. Good evening, everybody. As Rosemary said, this session is going to be on child protection law and family law. I'm going to speak first on child protection law, which is an area I practice in. So just next slide, please. So, firstly, I just want to outline the main legislation in Ireland for childcare law. The Childcare Act 1991 outlines the key responsibilities and obligations of the Child and Family Agency, which is also known as TUSLA. So the Child and Family Agency is the state body for the responsibility for childcare law in Ireland. Section 3 of the Childcare Act imposes an obligation on the Child and Family Agency to promote the welfare of children who are not receiving adequate care and protection. It is the role of the Child and Family Agency as the corporate parent of children in care in Ireland. They also regulate access for children in care and care planning for children in care. Next slide, please. So you should always inform TUSLA, which is the Child and Family Agency, when you have reasonable grounds for concern that a child may have been or is at risk of being abused or neglected. TUSLA has developed a web portal to allow for the secure submission of child protection and welfare concerns. And I have put up a link on the slides that you can access the portal on the TUSLA website. If you think the child is in immediate danger and you cannot contact TUSLA, you should contact the Irish Police, the Gardaí, on 112. Next slide, please. So the next section of the Childcare Act that I want to discuss is Section 4, which states that where it appears to TUSLA that a child who resides or is found in its area requires care or protection that he or she is unlikely to receive unless he is taken into its care, it shall be the duty of the agency to take him or her into its care under this section. Next slide, please. Section 4 also states that the Child and Family Agency is not authorised to take a child into its care against the wishes of a parent having custody of him or her, or of any other person who has custody of that child, or to maintain in its care any parent who wishes to resume care of the child. Next slide, please. So the next sections of the Child Care Act that I wanted to mention are the most common legal proceedings under the Child Care Act. Firstly is an emergency care order, and that's under Section 13, and that allows a child to be in care for a period of 8 days in emergency situations. The next section is Section 17, which is an interim care order. So that's a longer term care order made by the courts. And just to explain, these are all orders that are made by what's called the district court, which you may have heard in other previous webinars, which is the lowest jurisdiction of court in Ireland. So an interim care order can be extended then for longer periods if there was consent from parents. The next section then is what's called a full care order, and that's under Section 18, and that permits the Child and Family Agency to have care of a child until the child reaches their age of what's called majority, which is when they become an adult, which in Ireland is the age of 18. There are just two other provisions on the slide that I want to mention. The first is a supervision order. That's a situation where a child remains at home, so the child is not in the care of the state, but the court order allows the Child and Family Agency to visit the child. So social workers are allowed to visit the child in the family home to make an assessment. And finally is Section 47, which allows the court to make any directions in relation to a child in care if it affects a child's welfare. So that may be, for example, where a child needs urgent medical care, but the parents are not consenting to that medical attention, and that allows the court to make an order dispensing with the parental consent in respect of that medical treatment. Next slide, please. Just to go back to the emergency applications, so what can happen is that a child is removed from a place of risk by the Irish police if the police are of the view that there is a serious and immediate risk to the child. And what happens then is that the Irish police are obliged to hand the child over to the Child and Family Agency. The Child and Family Agency must then make a decision whether it is appropriate to make a court application for an emergency care order, or if not, to return the child home. So that must be done within a period of 72 hours or 3 days. And there is also provision for the Child and Family Agency to apply for an emergency care order without the Irish police having removed the child in the first place. Next slide, please. So this slide just outlines common incidents of concern which would lead to a child coming into the care of the state. Firstly, a child is located with a parent who is unable to care for him or her due to alcohol or drug misuse. Secondly, parent is suffering from mental health difficulties and unable to care for child. The third example is where a child presents to hospital with an unexplained injury and the parent is refusing for them to remain in hospital. And lastly, if a young child is in a home unattended by parent or responsible adult. Next slide, please. So this slide just outlines what is the legal criteria for a child to come into the care of the state under Section 17. So the criteria essentially is that if a child has been assaulted, ill-treated, neglected, or sexually abused, and that the child's health, development, and welfare is likely to be avoidably impaired or neglected. Next slide, please. The next slide deals with a full care order, and essentially that gives the Child and Family Agency the power to have the like control over the child as if it were his parent, his or her parent. The Child and Family Agency can do what is reasonable in the circumstances of the case for the purpose of safeguarding or promoting the child's health, development, or welfare. And it also means that the Child and Family Agency can provide consent to medical treatment, passport facilities, and decide on a care plan. Next slide, please. Finally, I just wanted to discuss another very common occurrence in recent years in terms of children coming into the care of the Irish state, and that involves separated children seeking international protection. So separated children seeking international protection are defined as children under 18 years of age who are outside their country of origin, who may be in need of international protection and are separated from their parents or their legal caregiver. So these children may have high levels of vulnerability and have experienced significant trauma both in their home country and on their way to Ireland. Next slide, please. So what happens is the Child and Family Agency carry out an initial assessment of the child, and that assessment will include the possibility of family reunification in Ireland or another country, and that is always the starting point when a child who is unaccompanied comes into Ireland. The assessment will also carry out medical screening and follow-up medical care if necessary. The assessment will include a trafficking assessment and whether there's been any abuse, and the child, if necessary, will be interviewed, and if it's appropriate to do so at that time. There will also be psychological assessment and intervention if needed, a social care worker assessment, an educational assessment, and then housekeeping matters such as PPS, and finally, they will commence an international protection application for that child. So that's a brief overview of child protection law, and happy to answer any questions at the end. Sorry, just finally, just two links there that I've outlined in terms of information for those working with children or just for families, and this is in direct response to Ukraine. For the Ukrainian response that's outlined on the TUSLA website. Thank you.
That's great, Shane. Thank you very, very much for that. We're going to hand over directly to our next speaker, who is Elton Ryle. Elton Ryle is from Matheson Solicitors, and he's going to take the presentation from now. All of the questions you can put into the chat, and those will be gathered together and presented to the speakers at the end of the presentation. Thank you, Elton.
Great. Thank you very much, Rosemary, and thank you very much for the invite to speak this evening. I'm very happy to be talking about child safeguarding matters, and hopefully the presentation will be of some use to our viewers this evening. I might move to the first slide in the presentation, please, Rosemary. Garda vetting overview. Okay, so the topic for discussion this evening is the Garda Vetting Act, which is a piece of legislation that we have here in Ireland, which seeks to protect children and vulnerable adults from dangerous members of the community who would seek to have access to those children or vulnerable persons in working environments, in sports environments, or in volunteering environments. And we have one piece of legislation called the National Vetting Bureau Children and Vulnerable Persons Act 2012, which is the focus for protection in this jurisdiction. So we call it the Garda Vetting Act, and it is a significant piece of child protection legislation in this country. What it has done is it has set up a specific division within An Garda Síochána, which is the Irish police force, which is dedicated to maintaining databases of important information to ensure protection for children and for vulnerable persons. Garda vetting is mandatory in many circumstances, and the obligation will generally rest with the employer who is seeking to employ an individual, with the community organisation who is seeking to engage with somebody, or with the sports organisation who is seeking to hire an individual to work with that organisation. So what's in the databases? Well, the Garda Vetting Bureau maintains a number of registers on its books. The first is a list of registered organisations. So that will be a list of schools, medical services, community organisations, sports clubs, all of whom employ people to work directly with children and with vulnerable adults. And a list of those registered organisations is maintained by the Garda Vetting Bureau. The database also contains details of convictions and information that would be of concern in relation to individuals, which can then be accessed by way of Garda vetting disclosures. So if an individual is convicted of a crime such as assault on a child or sexual abuse of a child, those details will be maintained and recorded on the Garda Vetting Bureau's register. And when an application for Garda vetting is made, that information can be disclosed in the disclosure. Thirdly, there is a register of vetted persons. So that is a list of individuals who have been given the go-ahead or green light to work with children, and they are maintained on a constant basis within the Garda Vetting Bureau's register. When an application for Garda vetting is made, the application seeks access to information stored on the Garda Vetting Bureau's database. So if you are seeking to employ a new individual in a company, you will apply to the Garda Vetting Bureau to ensure that that person is not dangerous and is not a risk to children and vulnerable persons. Okay, so if I can move to the next slide, please, Rosemary, children and vulnerable persons. So going into a little bit more detail then, we must look at the focus of this legislation, which is children and vulnerable persons. In Ireland, a child is anyone who is under the age of 18. So that will involve children from preschool, primary schools, all the way up through secondary school system in this country. A definition of a vulnerable person then is anybody who is over 18, but who suffers from a disorder of the mind, has an intellectual disability, or some form of physical disability or impairment. And the legislation seeks to protect these individuals because they are considered less able or less empowered to protect themselves from dangerous individuals. And we have introduced Garda vetting to provide an extra measure of protection for these vulnerable individuals. Next slide, please, Rosemary. So let's look at work or activities with children and vulnerable persons. We need to establish what kind of roles, what kind of employment roles or volunteering roles would be captured by the Garda vetting legislation. So key examples of work and activities are in the list as follows, and anybody who falls under one of these categories will need to obtain a Garda vetting disclosure before they commence their role. So anybody working in preschools, schools, primary and secondary level, hospital scenarios, detention centres and accommodation centres will all require a Garda vetting disclosure before they commence working in those environments. Similarly, one-to-one relationships with children and vulnerable persons, such as in therapy and counselling, in care and supervision of children, and in, I suppose, sports and social activities around education and training. Again, all of these individuals will need a Garda vetting disclosure before they can work, volunteer, or interact with children in those environments. Next slide, please, Rosemary. Now we look at relevant organisation. So who actually applies for Garda vetting? That's the question. Generally speaking, it will be the company or the person that is seeking to employ an individual to work with children or with vulnerable persons. And we have three key examples. The first one there is anyone who employs a person to undertake work or activities. So if my company, Matheson, employs somebody to act as a child safeguarding officer, because I am employing them, I must get a Garda vetting disclosure for them before they can commence their employment. Second example, where somebody enters into a contract with a person to work with children. So the example of the Santa Claus at Christmas party, that person might not work with Matheson, but Matheson might enter a contract to employ somebody to work as a Santa Claus for a party. That will be a Garda vetting scenario, and the Santa Claus individual will need to be Garda vetted before they come to work in Matheson. The third example then is where somebody permits any person to undertake work with children on their behalf. So an example there would be if my company sends a lawyer to a school to do reading lessons or tuition lessons with children or vulnerable persons, my company would be permitting those persons to work with children. And in that scenario, my company must get a Garda vetting disclosure for that person. There are a number of exclusions to Garda vetting, and unfortunately, the wording of the legislation is a little bit unclear, and there is only a very small number of cases in court on these exclusions. Some of the more simple examples would be work or activities in a family relationship scenario. So if I ask my brother or my sister to teach guitar lessons to my child, I don't need to get Garda vetting for my brother or my sister in order for that to happen. Similarly, in work or activities in a personal relationship with friends. So by way of example, if I go away for a weekend with my wife and my very close friend is minding my children for the weekend, I don't need to get Garda vetting for my friends in that scenario. There are two other exclusions which are a little bit more problematic and a little bit unclear. Firstly is private arrangements. The legislation excludes private arrangements made by an individual for their own private purposes. Now, unfortunately, the legislation doesn't give any guidance as to what a private arrangement is. Therefore, we have to be very cautious about that exclusion. Similarly, occasional assistance at a sport event can be excluded from Garda vetting. And I think the scenario that might apply there would be an individual who, say, sets up chairs for a school concert or sets up food for a school concert, but doesn't actually engage with children. Those potentially could be excluded also from Garda vetting. But the bottom line with the exclusions in this area is to be very cautious of any exclusion that may apply. So a question arises, why is Garda vetting necessary? The first and most important requirement is that it is a criminal offence not to comply with Garda vetting legislation in the appropriate circumstances. And the punishment for non-compliance can be a fine or imprisonment, depending on the extent of the offence committed. It's also very important to note that if you are asked to make or asked to give information for the purposes of Garda vetting, you must provide full and accurate information, as it is a criminal offence to give false information in a Garda vetting disclosure. Next slide, please. So the vetting process itself, how does it happen? An application for Garda vetting is made to the Garda Vetting Bureau by the relevant organisation. So that's the employer, the community organisation, the sports company. They will provide the name, the address and previous address, passport information, anything that identifies an individual who is seeking a role. That will all be provided to the Garda Vetting Bureau. The Garda Vetting Bureau then considers that information against the databases that it maintains on its files. If problematic information arises, so for example, if an offence of assault on a child occurs, the Garda Vetting Bureau will then contact the person who is seeking the employment role. They will be given an opportunity to object to or appeal the disclosure of that information if they disagree with the content of the information on file. If that process concludes, then the Garda Vetting Bureau will send the vetting disclosure back to the employer, to the community organisation or to the volunteer group. That relevant organisation, so the employer, then makes its final decision as to whether or not it wants to employ the person who is applying for the role. Garda vetting generally reoccurs at set intervals. So if a person is employed for a particular role, they will generally be re-vetted every 12 or 24 months, again, to make sure that the information is up to date and nothing has arisen since the last vetting disclosure. So next slide, please, Rosemary. What type of offences will be disclosed in a vetting disclosure? So at a high level, any offences that would give rise to a concern that an individual would harm a child or a vulnerable person will generally be disclosed in a Garda vetting disclosure. So if an individual has an offence of domestic violence, of assault, assault on a child, and certain offences around firearms, liquor and public order, those offences will generally be disclosed in a Garda vetting disclosure. Then last slide, please, Rosemary. And how does the Bureau keep its information up to date? So the legislation establishes the Bureau and it establishes the various databases that the Bureau can maintain. The Bureau is reliant on key organisations within the Irish state to keep its information up to date. These are called mandated bodies. So key state organisations such as TUSLA, the HSE, the Teaching Council, Medical Council will routinely provide information to the Garda Vetting Bureau. Just unmute myself there, sorry. If information comes to light that is of concern, these public bodies are obliged to investigate the matter and to send that information to the Garda Vetting Bureau to make sure that their databases are constantly kept up to date. So that is a general overview of Garda vetting, and happy to take any questions at the end of the presentation. Thank you very much.
That's wonderful. And thank you so much, Elton, for those questions. And I know there are some follow-up questions regarding Garda vetting, but we're going to go to our final speaker. And just to close out our session, today we have Gavin Rothwell. And apologies, Gavin, you were unmuting yourself at the same time as I was unmuting you. So I'll place the spotlight on yourself and move the slides on to your part of the presentation.
Thank you so much, Rosemary. Good evening, everyone. Thank you so much for having me on this webinar tonight. It's great to see so many people on the call, and I hope you're welcome here. And I hope you're continuing to feel welcome here in Ireland, despite the difficult circumstances. So in my presentation, I'm going to speak about different applications that you can bring in court in Ireland in relation to certain family law matters, especially regarding children. And as you can see from my slides, I want to briefly discuss three kinds of applications. Firstly, applications relating to children. Then secondly, applications relating to domestic violence. And thirdly, applications in court relating to couples that wish to separate or divorce. And then one thing I want to say before I just go through these points is just to explain that in Ireland, we have two kinds of lawyers. And I'm just explaining this in case you get confused at any point if you're navigating the Irish legal system. So in Ireland, there's a lawyer called a solicitor, and they're like Shane and Elton, who you've heard from already tonight. And a solicitor is the lawyer who's the first person you go to if you have a legal problem in Ireland. And then in Ireland, we have a second kind of lawyer called a barrister, or maybe you might call it an advocate or a trial lawyer. And I'm the second kind of lawyer, a barrister. So in the movies and in real life, we're the people who wear the long black robes and the wigs, the funny wigs on our head. I'm one of those. And barristers, we specialize in advocacy and in courtroom work. And so if you have a legal problem in Ireland, you're likely to use both a solicitor and a barrister, but a solicitor is the person you go to first. Okay, so I'm going to move on to the next slide now. Court applications relating to children. And so there's a number of levels of court in Ireland, starting off at the district court, which is the lowest level, going right up to the Supreme Court. But applications relating to children are usually heard in the district court. And it's important to note that privacy is very much respected in the legal system in any family or childcare matters. So if you have a case relating to a child, that will be heard privately. The courts will use the Latin term in camera, and that means that you or your children won't be identified publicly in relation to that case, and also that when your case is being heard, everyone else has to leave the courtroom and only the people involved in the case get to stay. And in all applications relating to children, you can apply for free legal aid. There's no guarantee that you will get it. But if you meet a certain financial threshold, or if you're below a certain threshold, you will be able to receive free legal aid. The Legal Aid Board is the organization that can provide you with a solicitor and maybe a barrister too. And I've provided a link there. legalaidboard.ie is the website, and you can apply there for a solicitor. So the next slide, please. There are four main kinds of applications which are very common in Ireland in relation to children. And it's possible for you to bring one or all of these in a case if you have concerns about your children. And the first kind of application you can make is called access. And this is a case you take if you're concerned that you are not being given enough time with your child. So an access application is usually taken by one parent in a family that has split up, that's separated or divorced. So if you are if your ex-spouse or ex-partner has day-to-day care of the child, and you're concerned that you are not seeing your child enough, or for example, your ex-partner is not letting you see your child, you can bring what's called an access application and request that a judge in Ireland direct that your ex-partner help you or facilitate you in seeing your child and spending time with your child. Usually it would be once a week or maybe twice a week or more, depending on the circumstances. So an access application is one possibility. A second application which we have in the Irish legal system is called custody. And this is like a step up from access. So it's day-to-day care of your child. So sometimes parents wish, when they separate, wish to have shared custody, which sometimes means one parent has the child 1 week and the next parent has the child the other week, and it goes on a rota. But sometimes custody, shared custody, can mean a parent looks after the child during the week, and on the weekends, Saturdays and Sundays, the other parent looks after the child. So if you feel that you're in a position to parent your child and you wish the court to make a direction that you have day-to-day care of your child, you can bring a custody application. Then thirdly, if you're the parent of a child, or even if you're a relative and not the parent, there's provision in Irish law for you to bring a guardianship application. And a guardianship application means that if you're appointed guardian of your child, it means that you have legal responsibility for your child. And this means you have responsibility in relation to certain important areas, such as the health of your child, education of your child, certain important matters like where the child might go on holidays every year, anything that's kind of not related to the day-to-day care of the child, but is on a more higher or important level. You can apply for a guardianship. And the fourth kind of application that's very common in the Irish courts is called maintenance. And this usually occurs where you have split up with your partner and you wish for your partner or your ex-spouse to contribute financially to your child's expenses. So this usually looks like a payment made every week or every month into your bank account. And usually a court, when it looks at an application from someone for maintenance, it will ask for documentation to prove that you need more money, to prove that the child has certain medical or educational expenses. And then it will if the respondent to a case, be it the respondent mother or father, doesn't want to give maintenance, the court will look for paperwork from the respondent to see how much they can afford to give on a weekly basis. But generally speaking in Ireland, if you're the parent of a child, you are expected to contribute financially to the child, even if it's only a minimum amount per week. And even if it's only €10 or something small like that a week, a court will still make an order that a parent has financial responsibility and obligations toward the child. So then if I could just move on to the next slide. The organization I referred to a few minutes ago that provides free legal aid also provides a service called mediation. And mediation is a kind of discussion setting with someone who's called a qualified mediator. And they're kind of like a judge, but they're much more informal and they're much more trying to help you solve your problems by talking. And the Legal Aid Board has what's called a mediation service. And you can apply to the Legal Aid Board for mediation if you feel that instead of going to a judge to ask him or her to make a direction on or make an order in relation to what you're looking for, you could ask the Legal Aid Board to refer you to mediation to try and have some informal discussions about the case to try to resolve things with less intensity and less friction. And if you're concerned that the court is not getting accurate information in relation to your case, because maybe you don't trust what your partner is telling the court, you can ask the court to order a report by an independent person into the child's welfare, or ask the court for what the child's views are via that independent person. Next slide, please. So in addition to applications about children, you can apply to the court for certain protections if you are the victim of domestic violence. And domestic violence is taken very seriously by the Irish courts and by the police on Garda Síochána in Ireland. And if you have any concerns that you are experiencing violence, and violence can mean physical violence, it can mean emotional abuse, it can mean sexual abuse or violence. If you have concerns that you're being treated by a partner or a family member in relation to those areas, you can apply to the court for protection. And there's two main kinds of applications you can make. The first is a safety order. And if you're granted a safety order, it prohibits your partner or family member from acting in an abusive way towards you. And if you're granted a safety order, the guards can intervene very quickly if a safety order is breached or broken by your partner, if they act in an abusive way when an order is made. And if you feel you need protection immediately or urgently, you can go to court on a one-side only basis and seek a protection order. And that's the same as a safety order, but just lasts for a shorter period of time, and you can get that with only one side being present. The second kind of domestic violence application you can make is for what's called a barring order, and that prohibits someone from entering the family home if they've acted in a certain way. And usually it's because a court has decided that they've been abusive, either physically, emotionally, or sexually, to you or to family members. And that's quite a serious order to get because it prohibits someone from attending their own home. But if you need to get one on an urgent basis, you can apply for what's called an emergency or interim barring order if you need something quickly. Next slide, please. And some applications in relation to domestic violence can be made with just you in the court, but for a final order, a court will require both sides to be present. And if someone breaches a domestic violence order, the consequences are serious. There can be a fine of up to €4,000 or prison for 12 months, up to 12 months. And as I said, with child applications, domestic violence applications are also heard privately. So the evidence you give won't be reported and won't have your name on them. It'll just be between you and the judge and whoever's in court in relation to your case. Then finally, if we could turn to the next set of slides, please. So the final set of applications I want to mention are what we call separation and divorce applications. And if your relationship with your partner or ex-partner has broken down, you can apply to the court for a separation or ultimately divorce. And most applications are not made in the district court, which is the lowest level of court, which I mentioned earlier, but is made at the next step up in the circuit court. And if you have a lot of wealth or a high value of assets, usually over €3 million, you must make your separation and divorce application in the High Court. But most divorce and separation applications are heard in the circuit court. And because separation and divorce proceedings are more complex, they're longer, there's a lot more paperwork involved than the applications I discussed previously. It's strongly recommended that you get legal advice from a solicitor before proceeding. And you can either find a solicitor privately on the Law Society website, and you'd need to pay them, or you could apply to a law centre for free legal aid if you meet the criteria. And again, I've put the Legal Aid Board website on the slides. So next slide, please. In Ireland, there are a number of criteria that you must satisfy if you're looking to get a divorce. So you have to be living apart for 2 of the last 3 years. One party in the family must live in Ireland. You must show the court that there's no chance of reconciliation. There's no prospect of you moving back together as a couple. And the court must be satisfied that you have made proper arrangements, proper provision between you and your ex-partner to financially look after each other and financially look after your children and any debts you may have. And then next slide, please. So if anything I've said today in my presentation has concerned you, or you wish to find out more information, there's just a couple of websites I've listed that will be helpful for you to go to. So if you're a woman who's experienced any kind of domestic violence or abuse, or you think you have, and that could be emotional abuse, physical abuse, sexual abuse, there's a very good organization called Women's Aid, and there's a website there, and they will help direct you to the right services. Sometimes they will even accompany you in court if you're concerned or you're nervous. So Women's Aid is a very good website. Then if you're a man and you also have felt that you've been abused in some way, physical, emotional, sexual abuse, there's a special charity in Ireland that helps men who are victims of domestic violence, and they're a very good organization, and you can get help from there. Thirdly, I've listed the website of a legal charity called FLAC, the Free Legal Advice Centre, and they're an excellent charity that helps direct people who are in need to the right legal services. And if you have a question that you need a bit more in-depth answer to than just what I've given in this presentation, FLAC run a phone clinic where you can ring up and arrange an appointment to speak to a lawyer for 15 minutes for free. And they're a very good organization. And then finally, this is the same website that I've listed earlier. The Legal Aid Board has a website, and the Legal Aid Board have what's called a law centre in each county in Ireland. So it doesn't matter if you're in Galway or Cavan or Monaghan or Cork or Donegal or Dublin, there's a law centre in each county, and you can contact the law centre to ask how to get legal advice. So thank you very much for listening to me this evening, and I look forward to answering any questions in the question time we have now.
That's wonderful. Very many thanks to all of our presenters here this evening.